10 minutes each.
Yes, grateful to your Lordship, my Lord. Lord, petitioner always, Lord, thinks of, Lord, participation in these types of matters. Lord, in order to assert, my Lord, the state's autonomy and federalism.
Of course.
And my Lord, I'm grateful to the learned Solicitor General, my Lord.
Even otherwise, we are going to forgive.
Yes.
You
Grateful
be
to
grateful to him.
Yes, grateful.
Then if you are going to
Yes,
meet others,
yes, my Lord.
at least because
Yes.
of the live streaming, then
Lord, I have filed my written submissions.
yes.
Lord, I have divided into two parts. Lord, page number 1 to 11, my Lord, is a key to my written submissions. Volume 2.14.
1-4.
1-4. Lord, this article, Lord, we have been wandering in this court for a longer period. Lord, we have brought this special reference. And my Lord, we know the pain which we have undergone, Lord, in approaching the courts and ultimately, my Lord, getting an order in our favor. Lord, that is why, my Lord,
We are not going into
Yes.
the correctness
Yes.
or otherwise of the judgment
certainly,
of the
my Lord,
division.
certainly, my Lord,
We are only
I do-
restricting ourselves to the
yes,
question.
I bow my head, my Lord. I am grateful to your Lordship, my Lord.
So don't
Yes,
Personalize it.
don't
yes.
bring your pain before the court.
Lord, whatever may be, my Lord, today the states are celebrating this judgment. That's what I wanted to place it.
This is again,
Lord, yes. Now, my
You
Lord,
are-
see the legislative procedure. Yes,
When you argue a matter, it is expected that you
yes.
argue a matter with some sort of detachment.
Lord. Yes, certainly, my Lord, certainly. My Lord, I have to just place, my Lord, what has made us, my Lord, to come before this court. Now, my Lord, legislative procedure, this article 200 and 201, my Lord, falls, my Lord, under the heading of legislative procedure. Lord, this legislative procedure, my Lord, should be understood in the context of the Constitutional Assembly debates, rule of law, and, my Lord, the principles and approaches adopted by the constitutional courts. My Lord, therefore, this legislative process, my Lord, which your Lordship is going to interpret, my Lord, your Lordship has to take into consideration that the people's, my Lord, elect a government, my Lord, or a representatives, my Lord, with a fond hope that they will give good governance within 5 years. Therefore, my Lord, the legislative process should be fair, reasonable, uphold legislative supremacy, respect states' autonomy, support the federal structure, and promote parliamentary democracy. My Lord, that is what, my Lord, this 200, my Lord, altogether, my Lord, your Lordship has to look into it. So, therefore, my Lord, if your Lordship sees how, my Lord, Article 21, when the word, my Lord, procedure, Lord, is there in Article 21 is interpreted by this court in Maneka Gandhi. Lord, I have stated that, my Lord, in B. Lord, if your Lordship sees, I have enclosed that, my Lord, in page number 11, internal page number 11, 1506. Lord, Maneka Gandhi's case, my Lord, clearly says, Lord, at page number 1507, that the procedure should be fair, transparent, and, my Lord, addressing the functions of the governor, time limits and methods of handling bills, including reserving them for the President's consideration and setting time limits for the President's action in terms of constitutional scheme falls well within the jurisdiction of this Constitutional Court and judicial manageable standards envisaged in the Constitution. The Honorable Court is tasked with the ensuring that both the procedural and substantive validity of any legislation align with the constitutional provisions. This includes interpreting the relevant procedures clearly and ensuring the effective functioning of constitutional institutions, not constitutional institutions including governor. This in turn enables the upholding of rule of law, delivering good governance. That's very important. For a people, we go before the people, we get elected, we come, Lord, and form the government, and Lord, we have to, Lord, give good governance. Lord, that is very important, and within 5 years, Lord, we have to do it. And therefore, Lord, there's a meaningful participation by the representatives of the people. These elements are essential for maintaining parliamentary democracy. Therefore, this Honorable Court is well within the time limits to interpret the legislative procedures embodied in Article 200 and 201 as exercised by the Governor and the Honorable President. Then, my Lord, I have also said, Lord, at C, paragraph C, my Lord, in my key to the written submissions, my Lord, page 1497, a judgment of this court, my Lord, in Roger Matthew versus South Indian Bank Limited. My Lord, if your Lordship sees, my Lord, page 12, I have extracted that judgment. Kindly see, my lord, page 12, 1507, para 11. My lord, in Roger Matthew, whether, my lord, the court can go into the legislative, test the legislative procedure. My lord, this court said, my lord, paragraph 11, I have extracted. Since the Constitution explicitly provides a self-contained detailed procedure for enactment of legislation and does not suggest that mere assent of the President to a law by whatsoever method adopted would become a valid law, it is necessary that this court, being the highest constitutional forum for judicial review, is provided with enough space for enforcement and protection of the constitutional scheme. Thus, a mere presidential assent does not validate a law by any method. The Honorable Supreme Court, being the highest constitutional forum for judicial review, must be provided with enough space for enforcement and protection of the constitutional scheme. Then, my lord, I have also, my lord, quoted Kaiser Hind, my lord, 2002, 8 SEC, page 182.
Roger Matthew is with regard to the power of this court to examine whether the law violates any of the provision of the Constitution or not.
Not, my lord, including the procedure, my lord, which is set out in the Constitution. My lord, because the procedure, my lord, 200 and 201 comes, my lord, under the heading procedure, legislative procedure. My lord, my humble submission would be, my lord, this court is empowered, my lord, to see whether the procedure which your lordship is going to, my lord, interpret as per the constitutional debate, my lord, is fair and reasonable, so that, my lord, it takes into consideration all aspects. Then, my lord, this Kaiser Hind also, my lord, if your lordship sees page number 11, my lord, paragraph 12, my lord, I have extracted this Kaiser Hind. My lord, that relevant paragraph, my lord, at page number 12, at paragraph 12, my lord, para 29, my lord, it says, we further make it clear that granting of assent under Article 254(2) is not exercise of legislative power of the President, such as contemplated under 123, but is part of the legislative procedure. Whether procedure prescribed by the Constitution before enacting the law is followed or not can always be looked into by this court. Therefore, my lord, the granting of assent is not exercise of legislative power, such as contemplated under the Constitution, but it's a part of legislative procedure. And, my lord, held that the procedure prescribed by the Constitution before enacting the law is followed or not, my lord, court can always look into that. Then, my lord, with regard to the immunity, my lord, at page number 1497, my lord, my lord, I have said about the Rameshwar Prasad 2006 2 SEC, page 1, my lord, where immunity available to the governor does not take away the power of the court to examine the validity. Then, my lord, I have also extracted S.R. Bomey's case 1994 3 SEC, page 1, where, my lord, judicial review is a basic feature of the Constitution. The arm of the court is long enough to reach injustice, and actions of every highest constitutional functionary is subject to judicial review. And if your lordship sees, my lord, state of Rajasthan, my lord, that I have extracted, my lord, at page number 14. If your lordship sees, my lord, page number 1509, para 15, the state of Rajasthan is very important, my lord. Para 149 particularly, it says, this honorable court held that whenever a question arises as to whether a constitutional authority has acted within or exceeded its powers, it is a constitutional duty of the court to decide it. The Constitution is the supreme law of the land, binding on every organ of the government, executive, legislature, and judiciary alike. No authority, however high, can be the sole judge of the extent of its power under the Constitution. This court, as the ultimate interpreter, is entrusted with the task of defining the limits of power, ensuring that no branch transgresses them, and upholding the rule of law by enforcing constitutional limitations. Then, my lord, I have also extracted this Roger Matthew. Again, my lord, with regard to the interpretation of Article 212, my lord, to what extent, my lord, the court can go into the legislative procedure. My lord, if it is illegality, then, my lord, the court said, we will go into that. I have extracted, my lord, in page number 14. And so far as the judicial review is concerned, my lord, I have extracted, my lord, the judgments of this court, my lord, in fact, my lord, from paragraph 17, my lord, at page number 15, my lord, I have made a tabulations, my lord, S.R. Bomey's case, BP Single's case, paragraph 17, if your lordship sees, my lord, S.R. Bomey's case, BP Single's case, Kalpana Mehta's case, Rajaram Pal, State of Rajasthan, A.K. Kaul, Kaiser Hind. My lord, in all areas, my lord, there the judiciary, my lord, has interpreted, and that's how, my lord, the institutions are functioning. My lord, this is an area where, my lord, till, my lord, this Tamil Nadu state was Tamil Nadu governor fixing the deadlines. My lord, it was an area, my lord, where it was subject to interpretation. Now, my lord, that area is also settled. Now, if your lordship comes to, my lord, the questions, my lord, that is posed, my lord, by the honorable president. My lord, so far as question number 1 and 2, my lord, please come to page 3, my lord, of my keynotes. My lord, extent of power given to the governor. My lord, we are here, my lord, quoting Dr. B.R. Ambedkar's, my lord, speech. My lord, if your lordship comes to page number 18, my lord, I have quoted B.R. Ambedkar's speech, my lord. Where, my lord, he says, my lord, at page number 18, para 20. But where he says, yes, my lord, kindly come to 21, my lord. My lord, this is what, my lord, we expect. My lord, in fact, an assurance is given by, my lord, Dr. B.R. Ambedkar, my lord, when all states were coming together. The drafting committee felt, as everybody in this house knows, that governor is not to have any kind of functions. To use a familiar phraseology. Yes. Lord, this word was not read, that's why.
Already
Going to read, my lord, then I'll skip it, bro. Grateful to your lordship, my lord. Then, my lord, your lordship kindly come to, but how this article, my lord, 175 and, my lord, 91 was made, my lord, much argument is made. My lord, I am skipping that, my lord. And, my lord, my submission would be only that, my lord, there are only three, my lord, ways, my lord, where it was argued much, my lord. And, my lord, always the governor has to act under the aid and advice of the Council of Ministers. Now, my lord, with regard to the false through, my lord, much argument was made on the basis of, my lord, Alluri Basavia Chowdhury. My lord, our submissions would be, my lord, the will falls through means bill dies where it is born. My lord, governor cannot withhold, my lord, bill on his own and bury it at Rajbhavan. My lord, as explained in the Constituent Assembly debates, it can be only exercised under the aid and advice of the Council of Ministers. And, my lord, why it is, my lord, sent back, withhold is, my lord, to remedy a hasty action, or when the ministry or the government changes before the bill is assented by the governor and a new ministry is
That is
formed.
already argued.
Yes, that is argued. My lord, in fact, Samsher Singh, Nabam Rabia, my lord, Kaiser Hind says, my lord, at page number 35, kindly see, my lord, page number 35. My lord, this is a page number 35. Lord, they say, Lord, will is nothing but expression of political will. Apparently, the will of the people expressed through the legislation passed by the elected representatives. To that extent, my lord, I'm quoting this. And, my lord, the governor, my lord, he can't be a constitutional court, my lord, that we have, many of them have argued. Now, my lord, you should kindly see one of the important submission is, my lord, this federalism, my lord, ingrained into the constitution. Lord, what Dr. Ambedkar said, if your lordship comes to, Lord, page 37, Lord, I have extracted, Lord, Dr. Ambedkar. Our fear is, Lord, whether the federalism or a state autonomy is going to be lost. Lord, in the exercise of, Lord, interpretation of Article 200, kindly see, Lord, paragraph 40, what Ambedkar said. Lord, this is on 26th November 1949.
25th.
There is only one point of constitutional import to which I propose to make a reference. A serious complaint is made on the ground that there is too much of centralization and that the states have been reduced to municipalities. It is clear that this view is not only an exaggeration.
Already, we have read it so many times.
This is not read, my lord.
It is read.
Yes, my lord. Then I skip that, my lord. Then your lordship kindly, yes. Then your lordship kindly see, my lord, the time taken by the bill.
Where Dr. Ambedkar says that insofar as states are concerned, they have an exclusive right to legislate on them.
Partition, the power is partitioned between the state and the
As
central.
Parliament is concerned, this has been read so many times now.
Yes, and how the constitution has to work.
You had your 10 minutes
Yes,
now.
Lord, I will finish it off, Lord. But if your lordship sees, Lord, the constitutional silence, Lord, courts have interpreted, Lord. Yes.
Mr. Wilson, the only new thing which, of course, no one has referred to is your diagram at 1527. So better you rely on that.
Grateful to your lordship, my lord. One thing.
Colorful also. Colorful.
A colorful diagram, my lord. Yes, my lord. My lord, I will just skip, my lord, certain points, I'll summarize. My lord, I have said about the constitutional silence, my lord, which your lordship can interpret, my lord. This has been said in Krishna Kumar Singh, Jai Shri Ram Patel, Kesavananda Bharati, and K.S. Puttuswamy, my lord. This court has said, constitutional silence is a dark matter like dark matters in physics. These elements are not directly observable in the text, but without them, the constitution would collapse in incoherence. My lord, that paragraph, my lord, I have marked, my lord, page 46. Then, my lord, I have extracted, my lord, the judgments, my lord, where they said about the constitutional silence. And, my lord, because of this Article 356 interpretation in S.R. Bomai's case, today, my lord, we are saved, my lord, from indiscriminate dismissal of the, my lord, by the governors. And, my lord, if your lordship sees, my lord, this as soon as possible, my lord, the interpretation, what H.V. Kamath feared, my lord, that is a fear coming to us, my lord. That is a fear, my lord, that I've, my lord, stated in page 53, my lord, para 56. My lord, what will happen, my lord, if the timeline is not fixed? Then, my lord, I will be, my lord, wandering in courts. I have given a schematic diagram also, my lord. My lord, therefore, my lord, the court cannot be a mute spectators, my lord, and I cannot, my lord, court cannot be one of the layer between the governor and the act coming into force. Every time, my lord, I cannot come, my lord, I filed a writ petition in 2023. I'm giving one example. My lord, and 2025 only, my lord, the judgment was delivered. Nearly 2 years, my lord, I was wandering in the courts. Therefore, my lord, my humble submission would be, my lord, this timeline also, if your lordship sees, there is already a memorandum, my lord, which we have enclosed. Your lordship would kindly see, my lord, that memorandum at page number, Lord, 1551. This memorandum is extracted, my lord, in the judgment of Tamil Nadu government versus Tamil Nadu governor's case. This memorandum, my lord, passed by the central government, clearly says has got the approval of the cabinet, which says 3 months, my lord, the bill has to be disposed of. My lord, I have, my lord, enclosed at page number 1551. My lord, when the government itself, my lord, have decided to decide, my lord, all the bills within 3 months, and cabinet has approved. My lord, when cabinet has approved, my lord, it has got a flavor of Article 73. My lord, it becomes a law. My lord, what is difficulty now, my lord, in court saying that, my lord, within 3 months the bills have to be disposed? Therefore, my lord, they will not have any difficulty, my lord, in dealing with this because they already have a mechanism like this, but they are not doing it. Page number 1551, my lord, I have extracted that. So, therefore, my lord, my humble submission would be that the advisory jurisdiction, my lord,
Yes, yes. Mr.
advisory, my lord, I am concluding.
Yes, you are
Concluding,
your
my lord.
time is-
Advisory jurisdiction, my lord. Only when, my lord, there is a law that arises for consideration, my lord, the president can refer it under 143(1). But here, my lord, there are list of laws, my lord, I have enclosed a list at page number 70. Kindly see, my lord, page number 70. All questions, page number 70. My lord, I have given a tabulation. My lord, Tamil Nadu government versus Tamil Nadu governor is a complete answer for all, including, my lord, other cases. I have given all, my lord, the judgments, my lord, the questions raised in, my lord,
Thank you,
by
thank
the
you, Mr.
person.
Bill. Thank you.
And, my lord, lastly, my lord.
Thank you.
Yes, yes. And, my lord, this, so far as 91, my lord, when it was, my lord, debated, they say that similar, my lord, be applied to 175. My lord, why they say is, my lord, your lordship would kindly see these timelines. If the bill returned by the president, my lord, this is there at volume 28. My lord, this alone your lordship may note it, my lord. My lord, why the timelines, my lord, was skipped, my lord, when Article 91 had 6 weeks? Yes, my lord, they wanted, my lord, the bill as soon as it comes
Sir,
back.
you have-
Yes. My lord, therefore, my lord, my humble
Thank you.
submission would be, my lord.
We are granted you 10
Yes,
minutes. You have
Lord,
taken-
this judgment, my lord, that is in place, my lord, is really helping the states, my lord.
We are not concerned with the judgment. How many times we are telling you?
Grateful to you. All the judgments, my lord, I'm only referring to
How
all.
how many times we are telling you?
Grateful to you.
Don't get so much personally.
Grateful to you, lord.